And I'm going to call the meeting of the Board of Adjustment to order. I'm Ed Kramer. I am the chair of the Board of Adjustment. And to my left and to your right, there are name tags. These are the members of the Board of Adjustment. Let us have a moment of silence, please. Okay, thank you. So the first thing is a certification of a quorum, and as I look around the room, seeing 6 members out of 7, we do have a quorum, so we can conduct business and we can vote tonight. All right, I need a motion to adopt the agenda from any of our board members. Okay, moved by Amari Grambling. Any seconds?
Second.
Second. Any discussions? All those in favor? Aye. Opposed? Okay. Approved. All right. I need a motion to approve the adoption of our May 28th, 2026 minutes. Can I have a motion for that, please?
So moved.
Okay. Dan Sharp moved. A second. Second by Maury Grambling. Any discussion on the minutes? Additions, corrections, deletions? Hearing none? Okay. Minutes are approved. All right. So we are now going to open an evidentiary hearing for 427 Kentucky Road, PIN number 072007567500000. The applicant has requested a variance, and the property is located at 427 Kentucky Road.
Ed, turn your mic on.
Oh, it is on. It's on. Oh, okay. All right. This hearing is a quasi-judicial evidentiary hearing. That means it is like a court hearing. State law sets specific procedures and rules concerning how this board must make its decision. These rules are different from other types of land use decisions like rezoning cases. The board's discretion is limited. The board must base its decision upon competent, relevant, and substantial evidence in the record. A quasi-judicial decision is not a popularity contest. It is a decision constrained by the standards and the regulation and based on the facts presented. If you will be speaking as a witness, please focus on the facts and standards, not personal preference or opinion. Please pay attention to what I'm going to read here. Participation is limited. This meeting is open to the public. Everybody is welcome to watch. Parties with standing rights to participate fully. Parties may present evidence, call witnesses, and make legal arguments. Parties are limited to the applicant, the local government, and individuals who can show that they will suffer special damages. Other individuals may serve as witnesses when called by the board. General witness testimony is limited to facts, not opinions. Okay? All right. For certain topics, the board needs to hear opinion testimony from expert witnesses. These topics include projections about impacts on property values and projections about impacts of increased traffic. Individuals providing expert opinion must be qualified as experts and provide the factual evidence upon which they are going to base their expert opinion. Witnesses must swear or affirm their testimony, and I think we're going to swear in the witnesses as they appear. Is that correct? Yeah. Okay. Very good. All right. The parties to this case are entitled to an impartial board. A board member may not participate in this hearing if he or she has a fixed opinion about the matter, a financial interest in the outcome of the matter, or a close relationship with an affected person. Does any board member have any partiality to disclose and recuse themselves at this time?
No.
None.
I do have friends, like Ashton Phelps is a friend of mine, I understand he's a neighbor. But that's the fact we've not discussed.
Bill, get closer to your microphone, please.
Did y'all hear that?
Okay. All right. It is the policy of this board that a recused member shall step down from the dais. Hearing none of that, I will just finish the sentence. I have a seat and have the seat with the general public. Okay. All right, so let's proceed to ex parte communications. The parties to this case have rights for any ex parte communications to be disclosed. Ex parte communications is any communication about the case outside of the hearing that may include site visits as well as conversations with parties, staff, or the general public. Does any board member have any site visits to disclose?
Yes.
Yes. Okay. Okay. Very good. All right. Does any board member have any conversations or other communications to disclose?
I had a conversation with my wife, with Ashton, and with Rick Giles, who was the neighbor. Very simple conversations.
Can you give the general nature of those conversations?
My wife wanted me to, she went over it with me, and we discussed it. She knows that I couldn't make a decision there and did not make a decision. Ashton and I had a very brief conversation, and Rick Giles and I had a very brief conversation in which he said he was not participating. So.
Will any of those conversations have any bearing on your ability to make a decision today based on the evidence you hear? Okay. Will any of those conversations unduly influence the decision that you will make today? Okay. Mr. Chair, I have no concerns as counsel.
All right. Okay. I think it's a good time to just identify this gentleman. He is the town attorney. So for those of you who don't know, okay, he is our town attorney. Okay. All right. So based on the disclosures we've heard from the board concerning partiality and ex parte communications, does any member of the board or any party to this matter have an objection to a board member participating in this hearing? Okay, having heard none, we shall proceed with the hearing.
I'm going to get sworn in.
What?
I need to be sworn.
Yeah, okay, where's Angie?
Thank you.
Oh, there she is. Okay, so we're going to swear in the people that are going to testify, and
Do you swear to tell the truth, the whole truth, and nothing but the truth? So help me God.
I do. All right. So if we can start the PowerPoint.
you want to introduce yourself, please?
I'm Alexis Baker. I am the interim zoning administrator until Friday.
Okay,
All right. If you're ready, Josh, you can start the PowerPoint. Maybe you can't hear me. We can start the PowerPoint. Thank you.
Alexis, before you begin, Mr. Chair, may I just address one issue? We have a member serving whose term has technically expired, but there has not yet been an appointment placed. I just want to let the board know.
Right.
I've done some follow-up legal research. My understanding is that members whose terms have expired but who have not been officially replaced may continue to serve until there is a replacement. The public policy behind this is to allow continuity of government. I've just looked at the School of Government's website. That is still the current advice that they are given, and if anyone is interested in how that works, there is an article that they wrote called Holding Over After Your Term Ends. It was originally published in January 5, 2010, and updated in November of 2013. And actually, it's got a new title, Holding Over After Your Term Ends, parentheses, revisited. Anyone who's looking for more information on how Mr. Sharp has the ability to serve after previously being our chair can read that article if they'd like to understand. Yeah. And I'm happy to answer any questions if anyone has any specific questions about that.
Okay, hearing no questions?
Yeah.
Alexis, go ahead.
All right. A variance request was submitted by Philip and Linda Jung, applicants on behalf of property owners Julian and Nancy Lake for the lot address is 427 Kentucky Road, Montreat 28757, and described as PIN number 072007567500000. This variance request is to the Montreat zoning ordinance, sections 501.5, minimum front yard, and 501.81, minimum side yard, to reduce the front setback requirements from 30 feet to 10 feet on the eastern side of the subject property, and the side setbacks from 15 feet to 5 feet on the northern and southern side of the subject property, and to Montreat General Ordinances, Chapter K, Environment, Article 3, Stormwater Management, Section 305.1, to reduce the 30-foot stream buffer to 10 feet for the purpose of building a new one-story, single-family dwelling and workshop for a permanent residence. Next slide, please. I do want to make one correction up here. I did get that information from the Buncombe County property records, which showed that property to be 0.24. However, if you look at packet page 33, the surveyor found that it was 0.204. So I wanted to make that correction there. So we have the PIN number. The owners are Julian Lake, applicants Philip and Linda Jung. The current zoning and use is an R1 residential district, contains an existing two-story frame single-family dwelling. All right, next slide, please. So here is the variance to the front and side yard setbacks in the Montreat zoning ordinance and to the 30-foot stream buffer. So the front in R1 is 30 feet. The requested setback is 10 feet. The sides, the north and south sides, are 15 feet required, but 5 feet requested. And the rear west is only needed, 10 feet is only needed, and that is due to it abutting the Woodland zoning district. So typically, the rear setback is 20% of the mean depth of the property, not to exceed 35 feet, but because of where it's located near the Woodland district, it only needs 10 feet. Next slide, please.
Are you going to talk about the stream buffer too?
Mm-hmm.
It comes later.
Yep.
Yeah.
Yeah, the stream buffer is 30 feet with a 10-foot requested. Thank you. So here is existing site plan. A two-story house is currently on the property. The applicants are proposing to demolish the two-story house and replace it with a one-story house and workshop. So this is what is on the property right now. Next slide, please. The proposed single-story, single-family home and workshop are highlighted in a peach color. So we're going to go through that. Next slide. So, and if you can go forward, there's a little bit of animation for you. Mm-hmm. All right. The yellow line is the setback requirement in R1, and you'll see a pink line, which is the proposed setback. For the front yard setback near Kentucky Road, the R1 setback is 30 feet, and the proposed setback is 10 feet. Thank you. For the northern side setback, the setback is 15 feet, and the proposed setback is 5 feet. Okay. Similarly, the southern side setback is 15 feet, and the proposed setback is 5 feet. Okay. Next, as mentioned in the report, while the applicant requested a 10-foot rear setback, that is not required. While in general, the rear setback in the R1 zoning district is 20% of the mean lot depth of the property, not to exceed 35 feet. Since this property has its rear yard abutting the Woodland zoning district, only 10 feet is required. So basically, the rear setback line just extends farther along the rear western boundary to intersect with the proposed 5-foot side setback shown in pink. Finally, per Montreat General Ordinances, stormwater management, variances may be given for the required stream buffer requirement. The applicant is requesting a variance from 30 feet in green to 10 feet in blue. Keep in mind that the stream buffer variance, if approved, only applies to this property, even if the site plan and geographical representative may show otherwise. So you see it comes a little bit outside of that property, but it only applies to the property in question. All right, next slide, please. The subject property of the variance request is in the R1 residential zoning district. The existing two-story, single-family dwelling, which will be demolished, was built in approximately 1919 by the Buncombe County tax card for the subject property. The applicants seek to obtain a variance for the purpose of building a new one-story, single-family dwelling and a workshop. The subject property fronts on Kentucky Road. It is surrounded by the R1 zoning district to the north and south and the Woodland zoning district to the east and west. All right. Next slide, please. The slope of the subject property per the Buncombe County steep slope calculator is 9.38%. The subject property gently slopes downward from north to south. The subject property is not subject to the hillside development ordinance. All right, next slide. There is an intermittent stream near the subject property. The applicants employed a geoscientist from Equinox Environmental certified by North Carolina's Division of Water Quality to determine the presence of storm surface waters. This evaluation is attached to your report on packet page 34 through 45. The proposed new construction will be in the 30-foot stream buffer. As mentioned, the applicants requested a reduction in the 30-foot stream buffer to 10 feet per section 319 of the Montreat General Ordinances, Chapter K, Article 3. All right, next slide. I won't read these to you, but they are on your packet, page 21. These are the standards for granting variances under our zoning ordinance. Next slide. And on packet page 22 are the town standards for granting variances under the Montreat General Ordinances. So this is for the stream buffer. All right. Next page. All right, this concludes my presentation, and I'll stand by for any questions that you may have.
Okay,
Thank you so much.
all right. All right, so, thank you, Alexis. Board members, any questions for Alexis?
I do. I'm Danny Sharp, and I'm trying to understand the stormwater variance that is being requested is to build within the 30-foot setback that's required for an intermittent stream. Is that correct?
That's correct. So they're requesting to reduce it to 10 feet.
Uh-huh.
So the buffer is measured from the top of the bank.
Right, right. I was unclear in the report because it talked about a riparian something or another in the buffer, and that there was no riparian buffer required because I don't know why, because of all the animals that live in there and the presence of water and vegetation and that kind of thing. I could not understand. Like, it's a pretty important thing to have a stream buffer for those reasons, for those ecological reasons. And so why would we grant a variance for when there is clearly an intermittent stream in the presence of biological, all the things that are necessary to require it to be an intermittent stream? What would be the hardship that would be there?
I think that's up to the applicant to
Okay.
discuss that with you.
Okay. Then the second question would be, in the application, there was mention of this property being a smaller lot than neighboring lots, and one of the tests for hardship is trying to seek to understand that this property has a unique signature, footprint, smallness, some characteristic about this property that is different from other neighboring properties. And so as I read carefully the explanation of that hardship, I was trying to understand why that property seems to be smaller than the other properties nearby. And I was looking for evidence of that, and I was unable to really make any kind of I was unable to ascertain the accuracy of that understanding. And so it might be helpful for me to see other neighboring property sizes to make that comparison. um, to be able to base a hardship claim that this is a unique issue on that property. Is that clear, or?
Yeah.
Yeah.
I think that may be a question to put a pin in for now and
Okay.
let the applicant give their presentation and maybe ask the applicant that question. I'm not sure that that's a question that staff is in a position to answer. I believe what staff put forward was just the GIS map. And I
Right.
don't think staff would have any information beyond that.
And there was a point of clarity in that the staff could answer, and that is the property .20 of an acre, or is it .24 of an acre?
It's .204 according to their survey.
20.
.204.
Uh-huh.
Yeah. .24 was what was in the land records, but surveys tend to be more accurate than what is in the GIS records.
Okay, thank you. So, I'm happy to relinquish my seat. I've been fired once already. I mean, if you want to fire me again, just tell me to go packing.
No. Shh. Well, you have a seat in the audience. This is in the audience. Okay. Thank you. Okay.
Okay, good.
All right, stay. Thank you. Okay. All right.
Mr. Chair, may I have 1 second to speak with the board's clerk?
Sure.
Okay.
Thank you. Yes.
Hello, Aaron. Your name tag is right over there by Brandon's computer. You know who you are? You do. You know who you are. She's going to bring it up. Okay.
They were much larger type of situation. The big guys.
Oh, really?
It'd be good now.
Did you? She said Syria boat. Made that. I never had a hand in one sales. The yacht club, Hampton Yacht Club taught me how to sail. We had
Mr. Chair, with your permission, may I address the board about
Yes.
the late arrival of a member? We have Ms. Arrington Cox, who is an alternate member who has arrived late. I would leave the opportunity open for any applicant or any board member to make an objection to this, but my recommendation would be to have her step in, even though she's missed a little bit at the beginning of the meeting, and serve, subject to me asking a few questions to ensure that there are no conflicts or ex parte communications. And also, if she is comfortable to serve, knowing that she has missed some of the staff testimony. However, a lot of that testimony was contained in the staff report, so she's heard that. She may be able to get up to speed.
Okay. Any
Ms. Cox?
objections from any of the board members to what our attorney just mentioned? There are no objections? Go right ahead.
Ms. Cox, have you had any discussions outside of the hearing with anyone about this matter? So no ex parte communications. So have you visited the site? Have you visited the site that is the subject of this? Anything other than the disclosure of a site visit that you need to tell your fellow board members? Okay. What you have missed so far is the testimony of staff going over the staff report and the presentation. Were you able to look at the staff report?
I'm sorry, I can't hear you.
Were you able to look at the staff report in this matter?
I was.
Okay. Do you, Ms. Baker, would her reading of the staff report get her substantially up to speed to your testimony that you just gave the board? And if not, can you fill in any gaps that you think are pertinent?
I think the only gap that's different from the report that you have is that in the report, the correct acreage, according to the surveyor, is .204. The .24 came from the Buncombe County property records, but in general, we rely on surveyors to give us the proper acreage. So it's .204. Thanks. That would be on, give me a second.
I'm so sorry I'm late. Puppy paralysis for me.
We're glad you're here.
Page 12.
Yeah, so it's on page 3. And also, let's see, packet page 12, correct. Yep, packet page 12. And there is also the survey that is in the attachments, and that would be packet page 33.
Got it. Thank you.
Welcome.
All right, I think,
Mr. Chair, no concerns from council if you want to
okay,
proceed.
yeah, all right, we are going to proceed. So we're going to swear in the witnesses who are going to testify. We're going to do it one by one. So our town clerk, Angie Murphy, who is going to testify first? Okay. Yeah.
Swear to tell the truth, the whole truth, and nothing but the truth, so help me God.
Okay, great. All right, please approach the dais. State your name, interest in the property.
My name is Philip Jung, and my wife Linda and I are asking for a variance from the town of Montreat. I want to thank you all for your service to the town of Montreat and being present for this meeting. Linda and I are requesting a variance to the setback requirements of the town of Montreat for the property located at 427 Kentucky Road. We have this property under contract and are ready to close contingent on the results of the variance meeting. My address may be in Texas, but I've been to Montreat since I was 5 years old. Linda has come also, but only since she was 10, so I beat her here. Both of our parents were commissioned as medical and dental missionaries to the Congo in 1950, and of course that was from Montreat. So Montreat has been in our blood for well, in my case, for 76 years. So I love Montreat. So what I'd like to do is talk about the existing house, where it's located, and then the planned one-story house, which we plan to be there. And then we're going to talk about the stormwater management. And I thought the stormwater management and how they did it was very interesting. And so I've talked to Dan V. Walsh, who's the gentleman that did it, and so we can answer some of those questions. The existing two-story house was built in 1919, and one of the documents I saw, it said it was built in 1914. And the property survey performed June 17th of this year stated that the area is .204 acres, which is a good bit, which is smaller than the .24, .25 acres, and the acreage around there is closer to the .25. So .204 acres is 8,886 square feet, and .24 acres is 10,454 square feet, for a difference of about 1,400 square feet. So that's the property is smaller than the other property around it. The frontage on Kentucky Road is 45.46 feet from that same survey, where the property records that I saw showed that the frontage on Kentucky Road was 70 feet. That was a new revelation to us. And I talked to the surveyor about it, and 25 feet of the frontage, was deeded to the Walkers to the north, which is the property just to the north of 427. And I think that took place like in 1995. So it's been, those 25 feet were lost back then. But this discovery was made June 17th, and it was a new revelation to us. And another disparity revealed by the survey is the .003 acres in what's called deed overlap along the Kentucky side of the property, which .003 acres is not much, but it is a little bit. The current home is set back from the property lines as follows. It's 0 feet to the north. The carport actually touches the property line on the north side. It is greater than 30 feet on the east side. It's about 7 feet on the south side. And it's, by my scaling the survey, 24.7 feet from the west. And what we're planning to do is to build a one-story house on this property. It will be a 3-bedroom, 3.5-bath, single-family dwelling with a workshop. The setbacks being requested are 5 feet to the north, 10 feet to the east, 5 feet to the south, and 10 feet to the west. And now this has not gotten into the stormwater issue. So the next thing I'd like to talk about is the stormwater management. And basically regarding stormwater management requirements, the drainage, I call it a drainage ditch. The drainage ditch flowing in the front of this property comes from South Carolina Terrace, behind Miss Lila Ray's house and the Thielman's home. And the stream was evaluated by Mr. Dan V. Walsh, who is a geoscientist from Equinox Environmental, and he classified it as an intermittent stream. And in his words to me, he said it barely makes the classification as an intermittent stream, but it is an intermittent stream. And I found the way the classification was done to be very interesting, and so we spent some time talking about that. And I think from what Ms. Baker said, it was sort of a new thing to the Board of Adjustments. So the setback being requested from the intermittent stream is 10 feet. It's also important to note that the vertical distance from the stream bed to the elevation of Kentucky Road is 42 inches. So table is like 30 inches, so 42 would be like right here. And the distance from the stream bed to what I call the general elevation of this property is 72 inches. And so why is that important? It means that the Kentucky Road would have to be covered with 30 inches of water, flowing water, because it's flowing downhill, 30 inches of flowing water before the water would rise to the general elevation on this property, which is, I don't know, we were here during Helene when we saw the flooding, and we already have a home on Kentucky Road, so we saw the water flowing down Kentucky Road up a little bit further, and it might have gotten up to 3 or 4 inches on Kentucky Road, but it did not flood on the bottom. But just to give you an idea about the depth of this, it's a ditch in front of the property. The water level on Kentucky Road would have to be up 30 inches above Kentucky Road in order to get even up to the general elevation of this property. So getting into the work that Mr. Dabney did, he was looking, I think in general it says that if the difference between a continuous stream and an intermittent stream was 50%, but he said that's a way that they talk about it. But what he said was, and what he does is to look at the data of the stream, and he came out and did that, and he was trained to do that. But he looks at the roots of the plants that are in there, what the stream looks like, and then he also inspects it for mollusks, for animal life. And he did find animal life, and I think it shows it in the report that he issued. Let me see if I can find. Okay, that is on
Page 38, 39.
on his report, or is that the?
What we have, that's our number.
Okay, 38 or 39.
Maybe 40 is
I think it's packet page 44 is the stream identification form. And I think your letter, I think there was a letter as well. There's a letter on packet page 34.
Okay, and basically he's saying the specific field observations supporting this determination include the following: a presence of base flow and natural soil-based evidence of a high water table, substrate particle abundance and sorting that indicates flow, little presence of rooted upland plants within the stream bed, and the presence of benthic macroinvertebrates, aquatic mollusks, and in-channel structures such as riffle pool sequences. And then he gives pictures of those. And on one of the pictures, let's see, the third, fourth, the fifth picture in. Okay, that's for the high water table. The next picture, or figure 6, is a caddisfly larva indicating the presence of benthic macroinvertebrates. And then the next page also shows a benthic macroinvertebrate right in the center. And it's a mollusk. So there is some live animals that actually live in this stream. And as I understand it from him, the water flows often enough that it supports the life that's in these streams. I found it very interesting the way he did the analysis. So that is my report, and we request that you favorably agree to our variance request. So,
Thank you. Just stay there, because some board members may have some questions for you.
Yes, I have a question. I'm looking at packet page 34, the conclusion of Dan V. Walsh. He says, consequently, standard 30-foot riparian buffer.
Into the mic, please.
Consequently, standard 30-foot riparian buffer regulations, which apply to intermittent and perennial streams, do not apply to this specific feature. I thought that they would apply, and it says they do not apply. I don't understand why that would be.
I had the same question, and I thought it should say it does apply. And apparently it does apply, but I know that it says that.
So this is incorrect on what we're reading?
I think that's incorrect,
Are
yes.
we talking about the stream on the right by the road,
Yes,
Yes.
not the other one? Right, okay,
right in front of the house, right beside the road.
thank you.
Yeah.
Sorry to interrupt.
If you're familiar with that area, there's a stream. This stream starts on the other side
Right.
of South Carolina Terrace. It flows down behind Lila's house and behind the Thielman house and behind the next house. And then it goes under the road and it comes out about 14 feet from the end of the property in question, the 427 Kentucky Road.
I'm not a stormwater expert at all, but I've tried to understand it. Part of the issue for stormwater is the health of the stream bed, which is why we would have a 30-foot distance from the stream bed to ensure the health of that stream bed.
I assume that's why the 30-foot distance. It's 30 foot on each side, so
Right.
it's 60 feet wide.
Right. So to build a building close to the stream bed could potentially put at risk the health of the stream bed.
I guess so.
It seems like that's the issue, at least as I understand it, that's one of the issues that we're trying to address,
Okay.
is putting looks like a workshop maybe?
It's a
10
workshop.
Feet, 10
Yes.
feet from the stream bed puts at risk the security and health of the stream bed. Unless there's some mitigating factor to avoid that.
Yeah.
Yeah, okay, that's just a clarification I was trying to make.
Yeah. And I think that probably the biggest time would be during the construction of it.
All right,
Once it's built, I mean, the dirt that's there is already there.
right.
And it seems like it's packed pretty well from the stream bed on up into this property.
You know, we have a high bar for granting variances. It's a pretty serious public process that we go through because we take the variances very seriously. And so when we grant setbacks, we try to ensure all of the findings of fact and that kind of thing. And so one of the things that I'm struggling with is this is a new building, a new house, a new workshop that would be built, and it would actually increase it would move the building such that the setbacks would be affected pretty significantly, 5 feet, and then 10 feet on this side for the stormwater. And so I'm struggling to understand the hardship issue. You didn't address the hardship questions in your presentation, which is that's what we have to do to vote accurately, is we have to be convinced that the hardship issues have been properly addressed. Could you take those on, please?
I think you have a copy of that in your notes.
Yeah.
We do.
And basically, I will read what the requirement is, and then our answer to it.
Mm-hmm.
Okay. So it's MZO 310-42A. Unnecessary hardship would result from the strict application of the ordinance it shall not be necessary to demonstrate that in the absence of the variance, no reasonable use can be made of the property. And our answer to that, the width of this property was reduced on 2 occasions, resulting in a frontage on Kentucky Road of 45.46 feet and a total area of .204 acres.
Mhm.
Thank you, dear.
Okay, I think,
This small lot is a good bit smaller than the lots on other homes on Kentucky Road. The carport is currently on the property line. And the south side is 6.5 feet from the property line. And the the west side is about 23 feet from the property line. So yeah, the north, we're actually increasing the distance from the property line. The south, we're going about 2 feet further south. But you're right, on the front, we're asking for a 10-foot setback, where normally probably the building is 40 or 50 feet back from Kentucky Road.
Can I piggyback on that for a
Wait, wait.
second? With the,
wait 1 second, please. Are you finished, Danny? Are you finished answering
I was
Mr.
going to go
Sharp?
through the rest of the,
Only if you've been asked. You don't need to go through them unless you're asked.
okay.
So, go ahead. Mari.
what I wanted to do is kind of piggyback on that a little bit. You said that there was a significant amount of land that was deeded to the Walkers,
Yes, ma'am.
and when did that happen?
I think in 1995.
Okay. 1953? 53, 64, 90, what? Which one?
Mr. Chair, we should only have testimony
Yes,
from
let me
one
warn the
witness at a
audience.
time.
You can only speak out if you've been sworn in. Okay? No problem.
But we know it was before y'all started looking at this property to buy.
Oh, yeah, like 30 years before.
Okay, so the reduction of the property doesn't affect y'all except for the fact that it once was that size, but you knew when you were looking at it that it was no longer that size.
No, ma'am.
What happened with that?
The map from Buncombe County basically says it's still a 70-foot frontage on Kentucky Road. The survey done June 17th showed that it was 45.46 feet. So the 25 feet was missing. And I talked to the surveyor, and he said he's the one that brought up that it had been deeded to someone else. And he had a document, and I think I have a copy of it, with a date, and I think it's about 1995 that took place between the Lakes and the Walkers.
Okay, I'm trying to get straight in my mind as well. So in other words, when y'all were looking at buying the property, you thought it was bigger than it was?
Yes, ma'am.
Okay.
Well, we thought the frontage was 70 feet.
Right,
We knew it was a small lot, but it's smaller than we thought.
okay. Thank you. Thank you.
Yes, ma'am.
Okay. Any other, next board member? Bill?
Yes. I'm looking at the west side of the property and the encroachment into the area with the stream over there. And I'm wondering why you've put the house so far back there, the proposed house. Could that be moved eastward so that that doesn't violate that setback? What's the reason for that?
I guess it could be moved eastward. We had moved the house we were planning to build. We wanted, if you went by the setbacks that you had in 45.5 feet and put 15 off each side, you could build a 15-foot wide house. Now, the property does go back some as it goes east, but we wanted a house of a certain size. We'd rather it be wider than it is long. It's longer than it is wide right now.
So what you're saying is that the larger part of the house, if you moved it to the east, would encroach on the setbacks and maybe even the property line on the north?
Well, we'd asked for a 10-foot setback from the
Yep.
property line on the east side.
Right.
And we also looked at extending I guess if you looked at the front of the house, the left side of the house,
Yep.
we pushed the bedrooms back further, but did not get back to the 10-foot setback line.
But you're within the setback that's 30 feet from the stream
Well,
on the west side. I'm talking about the west side.
well, it's, I think, from what Ms. Baker said, it's a wild land, and so there has to be a 10-foot setback for that.
Well, I'm looking at the map that's on what you proposed. I guess it's the survey, but it's hard to tell. And it shows a 30-foot setback on the west. And the proposed building extends westward of that. It's pretty significant. Alexis, am I reading that
Well,
correctly?
So for the rear setback, it only requires 10 feet if it's near the woodland district. Otherwise, any other district, it's 20% of the mean depth.
But this says setback line is shown,
So when we look at variances, we only give them the minimum that they need. Since it's already a 10-foot setback, that is the minimum. That's already in our regulations, that the 10 feet.
well, I hate to be so dumb, but I'm looking at the map, this right here. And what it shows is a 30-foot setback on the west side of the property.
Is that because of its district?
And I don't understand that, because to me, it was more of a violation to put the house beyond that than on the east side. That really intruded.
Well, that's just within the zoning regulations. A 10-foot setback is required for any rear that's abutting a woodland district. I think the surveyor put that in correctly.
So that's incorrect. So it's
Yes.
really a 10-foot setback.
Correct.
Okay.
Can I have a follow-up? Are you
Soon as he's
finished, Bill?
Yeah, sure.
Do you have other?
I do, but you go ahead and follow up that if you want.
Yeah.
Okay. The other question I have, well, have you thought about moving it forward? Well, you just said that it would intrude on the north. And thinking about the closeness of the western side of the building, the other lots within there are not that far back. And so there's a sense that this is a real prominent area of Montreat. It's really the heart of the Montreat market, the heart of Montreat history, and the heart of the Montreat Historic District.
Mhm.
So this really intrudes on that. And I'm thinking other neighbors have lived with that, but you don't want to.
Well, we really didn't look at what other people were on the back. We mainly looked at what they were on the front.
Front.
And you have some houses that are less than 10 feet, probably 8 feet away from the road. The Thielman's property is probably 15 feet away from the road. And it has this intermittent stream behind it. And the intermittent stream is also behind the Ray's house.
Right.
So we did not really consider the backs of the other houses along Flat Creek.
Okay, so Flat Creek, and what you're telling me that this is really a 10-foot setback and not a 30-foot setback. Okay.
Who prepared the survey?
So
Who prepared the survey?
I can't, it says,
The applicant survey?
yes, yes.
Yes.
Okay,
Um,
All right.
And I could understand the confusion as well.
okay.
So there really is no violation on the Flat Creek side of it?
Yeah,
Okay.
the rear, correct.
That's what I wanted to, okay. Thank you.
Danny, you have a follow-up, you said?
Follow up to my first question,
Go
which
ahead. Yeah,
is
sure. It's a
about
conversation.
hardship. It's always the hardship question for me. The hardship question says that there has to be something specific or peculiar about the property different from neighboring properties. And you've made the case that this is a smaller lot.
It is.
And I would like to see the evidence of that. That would be helpful for me. Like, I look at the plat, the GIS plat, and the lots around it on either side of the road, above and below it, seem to be similar sizes, not exactly. So I just need to see that for me to agree with you that this is, in fact, a special case, this property being smaller. You said 18% from the other properties in the neighborhood. And that's really important for hardship questions. That's
Okay.
kind of the basis of how we determine whether that hardship exists and whether it's been met or not.
Yeah. Well, when I look at the plat of the properties along there, it does look like this is about the same size. The Walker property is significantly bigger. And then the data says that there's a 70-foot road frontage, when actually it's 45 and a half feet, so that significantly reduced that. What the records show is 0.24 acres, and what the survey measured was 0.204 acres, which is 1,400 feet smaller.
Yeah, I'm just trying to help you make the case, if you can, that this property is smaller than the other properties around it.
It is smaller, yes, it
And
is.
that's the case that I'm trying to see the evidence of.
Okay, I do not have data on the other properties. All I know is what it showed. And I would agree that, yeah, they all look like they're about the same size.
That being the case, it would be difficult for me to vote in favor of a hardship.
Okay, but the
Unless I could-
measured size of it, I mean, it's supposed to be like 0.25 acres, and it's like 0.2 acres.
I mean, I understand that.
Yeah.
It's just relative to the neighborhood is what the hardship case is based on.
Yeah, well, it was hard trying to get a house. We're trying to build a house, one story, because we'd like to spend the rest of our lives there, and really don't want a two-story house, even to get up to the second floor to clean it.
Yeah, I understand personal preference and those kinds of things. Just as an example, across the street, Rick's house, he made a hardship case based on the fact that he had a stream running in his backyard that was different from the other houses around.
Okay.
And that was true. We could see that. We could objectively understand that case being made.
Mhm.
That's what I'm asking is I need to see that for me to be able to approve that variance. I would need to see that.
Okay, I'm not sure how to show that.
I don't know. You've made some claims about 18% smaller than the other ones, and so I assume there was some data that had been gathered to make that claim. So
Okay.
that was the kind of thing I would like to see evidence of.
I think the 18% is based on the other property in the area being 0.25,
Mm-hmm.
and this is 0.204.
Mm-hmm.
When you do that, that's where the 18% came from.
Yeah.
It is a smaller property, and 25 feet of it was deeded to the Walkers.
I can see that being frustrating to find that out.
Well, it was. We didn't find it out until the middle of June.
Yeah.
When the survey came out.
Changes the conversation.
It does. Well, it did, and
I'm sorry for you and having to, that's a frustrating reality.
it is a frustrating reality. 'Cause we'd like to have, it's not a big house that we're planning to build. It's, I think, something 2,500 square feet, and there'll be a porch. Montreat's a great place to sit on the porch in the afternoon and talk to your neighbors as they pass by, and also being able to sit on the back and enjoy Flat Creek.
Well, thank you. That helps. You know, I've tried to explain what is helpful for me to know. So,
Well, it's the small size of the lot. It was very frustrating, but also it changed what we could put there.
Matt?
I have a question for you, and when I drove by, I couldn't answer it for myself based on this. Your proposed workshop is the thing that it has you requesting a 10-foot setback instead of more. What would prevent you from moving that proposed workshop back another 10 feet?
Okay, on the house, when you face the house, on the porch side, on the left-hand side, there's something sticking out. That is a garage. And so if I push the workshop further toward the west, then I don't have enough room to drive into the garage.
Now I understand.
Okay.
I understand that point.
That was something, I mean, we made the workshop a little bit wider so it wouldn't be quite as long.
Yeah, that's correct. Well, if I have a concern anyway about how close that workshop is to the road, and you're asking for a generous variance so you can get it so close to the road, maybe it shouldn't bother me. Maybe that's just an aesthetic thing on my part. But going back to a comment made about this being the center of the historic district and what Montreat is, I wonder about an outbuilding that is that close to the road.
Well,
I don't know. I don't know where my question is in there, but you answered the reason why you want it out that far.
okay. Yeah, it's so that we can get into the garage. It's about, I think it's 22 or 23 feet from the edge of the workshop to the garage door, which is, okay, it's getting sort of small, but it is doable to get in, and the garage would be a little bit wider, so it's not like you have to be right in the center of a small garage to get in. But we would like to have a garage there for the coldness in the winter and unloading groceries and things like that. Okay. One of the things that we had thought of is if there is a concern about where this, I'm going to call it a drainage ditch, comes out, we could go into the wall and build a concrete reinforced wall or with stone in there and then put dirt back if that was a concern. Another solution, it would be to extend that 24-inch corrugated metal pipe on to the end of the property. That would be ideal as far as I'm concerned. Then we could go ahead and cover it over. But I can't add to the 24-foot, that 24-inch corrugated metal pipe.
Mhm.
That's the 24-inch CMP is what that's called on the survey. But the town of Montreat could do it, and we could pay for that to be done. I think that would be a better solution than a retaining wall, but we could put a retaining wall in concrete and rock in there if that was a real concern.
Matt, you done? Okay, Bill?
I do have another question. I'm sorry, I'm just having trouble reading this. Would there be any reason you couldn't move the workshop up to the north side of the property beyond those setbacks? Did you think it would, I think it says parking drive up there now.
It says paved drive
Paved drive.
there now.
And would there be, and that would move it back from the road? Pretty
Well, that puts it
significant.
right in front of the house, in front of the porch.
Well, the porch, it would be further over than the porch, but it would be visible from the porch. You're
Yeah, it
correct.
would be.
Yeah.
And so from an aesthetics point of view, it was, actually, it would probably be desirable from an aesthetics point of view not to have it at all. Where's that piece of paper I had earlier? Okay.
Would you like to be sworn in? Yes, I think so.
Mr. Chair, I would let him finish his testimony.
Yeah, but she
and-
keeps coming up and back, and we're not sure.
Well, she has not said anything to the board.
All right,
I-
okay.
I don't have too much concerns with her speaking to the witness, unless there's objections from
I would like her sworn in.
someone else.
Yeah, all right, okay.
That's your wife.
I really would like her sworn in, personally. I really would.
And I believe before she addresses the board, she should absolutely be sworn in.
Yeah.
I don't think she's done anything yet that
No,
would count
but
as
we don't know when it's
testimony
gonna
before this
happen.
board.
I want to prevent that. So please, Angie, we swear this, Mr. Young, in, please.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
Okay. Feel free to stand up here with your husband.
Okay.
There you go.
I want to make sure that this witness is finished with his testimony before she addresses the board.
Okay.
And it looks like there is a fair amount of folks here. If anyone here is asserting standing, it needs to be made known before the board. If people are just here to observe or offer witness testimony in the hearing when the board accepts that, that's a different matter.
Okay. Okay, Mr. Young.
Yes.
Mr. Young, are you finished testifying, sir?
Unless you have more questions.
I have some questions. We have two more board members. Okay, George, do you have any questions? No. Arrington, do you have any questions? No. Okay. Go ahead, I have some, but you'll finish, go ahead.
I just have one quick question. Have y'all bought this property yet?
We have it under contract to buy it, and we're set to close
Immediately.
hopefully Monday.
That's,
Mrs. Young, are you,
I'm sorry.
you're sworn in, why don't you let your husband finish, okay? And then you can come up and answer. Who you're addressing your question to?
to Philip.
Okay.
I noticed on here that it said that it had been delayed until the 31st. And so I was just wanted to be sure that at this moment, you don't own that property.
I do not own the property. We do not own the property, but we have it under contract to buy the property. And it's sort of contingent on what the Board of Adjustments agrees to.
Okay, that's why I was asking the questions about the size of the lot and that sort of thing. Thank you.
Yes, ma'am.
Okay. Any other board members have questions? Okay, I have a few questions. Okay, this is for you, sir. Did you ever consider building a new home? I understand why you want to tear down this house. Okay, it's the dated house and et cetera, et cetera. But did you ever consider building a new home on the existing property without a request for setbacks?
Well, if I did that, the front of the house would be 15 feet wide, which I don't really think that's very good architecture to have a 15-foot wide front of the house. So I guess that's why, and the existing property is well in violation of the required setbacks. So to do anything, I'd have to come before the board for that.
Can you explain where the
Mr. Chair, to avoid confusion, can we just have one person
Yes.
standing at the
Yes,
podium?
I think if you have nothing else to add with your husband, you can have a seat.
Yeah, and again, ma'am, you are welcome to address the board. We would just prefer that it be one person at a time.
Okay, you talked about 15 feet. I visited the property. I'm not sure. It looks like a lot more than 15 feet.
Okay, here's how I get the 15 feet.
Yes.
If I follow your setbacks, the property is 45 and a half feet in width on Kentucky Road. As I come back, it does get wider than that, but at Kentucky Road, if I take out 15 feet on either side of the width of the property, I have 15 feet remaining. 45 minus
Yeah.
15 on one side and 15 on the other gets me 15 feet. So the house would narrow down at Kentucky Road, okay, and we're going to be 30 feet back from that. But that's where I'm saying the house would.
I'm actually, somebody can explain that to me. I didn't follow that. Where's the 45 feet frontage, and you say it's going to be reduced to 15?
Yeah, 15 feet setbacks on either side.
If we grant you the setbacks.
Okay, so I
Is that
have
correct?
15 feet in the middle that's left. Now, I go back and I get a little bit wider, so I get a little bit more room.
All right.
But I would probably still be, I think that the maximum width of the property is 58 feet, something like that. I think it's about 58 feet, which means if I take 30 feet out of that, I have 28 feet for the width of the house.
Okay.
At the widest point.
All right. Okay. Another question. Can you explain the relevancy in your answer to the sec of 310.42B, the relevancy that your lot is 18% smaller than other lots, and that's why it makes building a home very difficult? I don't understand where the hardship comes. I mean, why? Because your house is smaller than someone else's makes building a home difficult.
Well, we expected the property to be 70 feet wide until June 17th, until we got the survey. So that was a big surprise to us. You know, and we would like to have a house that's a
No, I
certain
understand.
size.
I understand why you would want to, but so that was a surprise to you.
That was a big surprise
Okay.
because the data that belongs to the town of Montreat says it's 70 feet. And it's not. It's 45 and a half.
All right. Another question I have is, what I'm struggling with is the unnecessary hardship that will result from strict application of these various requirements when you're asking for variances, but you're going to demolish the very property that you want the variances for. It's like to me, the way I'm understanding it, and we'll have a discussion, is almost you're fitting a house, and then you want the variance to fit the house that you wanted to build on it. That you're tearing down a house that you already have, and now you want variances to fit a house that you feel more comfortable living in. I'm struggling with that a lot.
Okay, the house is there is it's over 100 years old.
No, I appreciate that. That's why I asked my first question was, did you ever consider building a new home, one floor, without asking for variances? And that's why I'm struggling with you tearing down this house and then asking for variances so you can build a bigger house.
Well, I would like a one-story house.
I understand that.
And I can't really convert that house to a one-story house.
No, I understand that. I'm not asking that. That's not my question. My question is, you're tearing down the existing house.
Yes, sir.
And now you want us to you're asking the board to give you variances so you can build a bigger house, a one-floor house. And I'm not sure I see the unnecessary hardship in that.
Yeah, the width of the house that's being built will be less than the width of the house that's there right now.
Okay, I hear that.
You're right, and okay, the carport is on the property line now, and we're asking for a 5-foot setback from that. The south side is about 7 feet, and we're asking for 5 feet there.
All right. I have no further questions.
Ed,
Other board members? Matt, yes.
Just to follow, I do not understand from what I'm looking at, what you just said, that the existing house is wider than what you want to build. What this shows me is not that. You want more. You're building wider on the property, closer to the north and the south setbacks, right? Closer to the Walkers and closer to First Asheville's properties.
On the back side, I am,
Yeah.
yes, but in the middle, I'm not. In other words, the property goes from,
You're counting the carport then?
I'm counting the
That's how you're weighing,
carport as
okay.
part of the house, yes.
All right.
And it's on the property line, and the other side, the south side, is about 7 feet from the property line. And now I'm asking for, okay, it's not that different, but 5 on one side and 5 on the other, for a total of 10 feet.
I got my question answered. Thank you.
Okay, yes, sir.
Any other questions of the board members of the applicant? All right, you can have a seat.
Okay.
Did your wife want to, since she's sworn in, did you want to address the board?
Well, this has been quite a long situation that we've gone through, and a tremendous amount of expense, too, to try to get to this point. But I think the main thing that we all need to realize is that we came in to want to buy this piece of property and look at it, and it's 70 feet width. And we have a survey that's done not too long ago, finding out we only have 45 feet of width. And it's just like Philip said, if you take the setback lines, 15, 15, that's 30, and that just leaves you 15. And it doesn't widen out that much more. So the home that's going to be a reasonable sized home to put on it has got to be lengthened. So that's why, and Alex was telling us, well, we're okay on the back, but the front, when we found out later, when she called us, there's a drainage ditch situation here. And we are willing to resolve that in any way that y'all are comfortable with. We'll build a retaining wall, or we will be happy to pay for diverting the pipe that's underneath the ground, underneath the street, and to send it down a little further. It's a drainage ditch. I've seen it dry many times. And so it almost didn't get to the intermediate when we talked to the geoscientists. So actually, I don't think anything is unreasonable is what we're asking, because the present house is right on the survey line on the Walker's side and 7 feet on the other side. So we're just asking to be able to put a decent-sized home, which is a moderate home, and it still will have the cottage look, and place it properly on actually one of the smallest lots that we've seen. Now, most of them are much bigger. I mean, I didn't know that we were going to need to bring all the sizes of the lots, but the Walker lot is definitely huge, sitting next to us, and most of these have 70 feet width, and they're a little more acreage to them.
Okay.
So it's just, that's just where we're at.
Okay.
We wish we had more property to do a bigger house or do something without having to ask too many requirements, but we would love to be able to build this house and to live here. And we appreciate so much your consideration.
Board members, any questions for the witness? Okay. Are there anyone else want to address the board? Step up, need to be sworn in. Angie? Have to wait for the town clerk. Here she comes.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
Okay. All right, please, up to the mic, your name, address.
My name is Carlisle Willard. I am currently one of the managing partners of the Walker Wigwam, which we hold as an LLC for my kids. My wife, Lee Walker, is the daughter of Boo Walker, who built the place. He bought the property in 1963 and started construction in 1964, finished in about 1965. To address the 25 square feet, when he built the place, he wanted to have a driveway entrance, but because the lot was rather pie-shaped, he needed a couple of feet more space, so he bought an additional frontage space for that purpose. This is currently part of a planter between two properties at this point with the fence running down the middle of it. In 1995, my sister-in-law, who's the other managing partner of the LLC, took over the deed from her father, had it resurveyed, and the new and the current dimensions were put into place at that time. This is why the variance in the numbers, but the purchase of the change of the changes in the line, 64. That's all it is. I have only three first of all, let me say that I am in fair sympathy with Youngs. I understand their frustration. I do agree with them that the lot is rather small. But I do have a couple of objections, I'm afraid. First of all, the proposed house as structured, when my father-in-law built the house, he set it back toward the back of the lot. This was done for privacy reasons. If you look at the three houses on that lot, they were in a dead even row, which means that the backside windows of one house would look into the backside windows of another house. Boo set the house back enough so that his bedroom and bathroom windows are looking out on the back yards of the house to either side. I'm reminded of a situation that I ran across in North Raleigh back in the 80s when my wife and I toured a new construction there. The housing development featured very small lots and very large houses, and the houses were less than 10 feet apart. And when we were looking at the luxury bathroom of this one house, I looked out its window, discovered I was looking into the dining room window of the house next door. And I turned to my wife and said, "Look, Lee, enter in a show." So this is what I see the situation here. If the house is moved back to where it is, our neighbor on that side can look through our bedroom and bathroom windows. And I find that, and it, I think it decreases our property. So that may be, nobody's going to want to look at me getting out of the shower, so that's not really an issue, but it is a point of fact that our privacy would be reduced. My second point is that a variance is an exception. However, it is also a precedent. And that's actually what concerns me rather more. It is a precedent that changes the acceptable parameters. These setbacks were set in place for a reason, some for environmental protection, some for privacy protection, and this is a feature of all of the houses along this street as part of the historical setting of the houses. They are set apart enough from one another that you can't sneeze out your bathroom window and have it land on the window of the house next door. Allowing this variance breaks that precedent and sets one where every time someone builds a new house on a new property, they can crowd the variance lines. They already have this as a precedent, and before very long, we look like a row of townhouses with not much room between the houses. And I think that's a bad idea looking forward. My third point has to do with the ordinance selection. I was looking at section 310.42, section B. The hardship results from the conditions that are peculiar to the property, such as location, size, or topography, hardships resulting from personal circumstances, as well as hardships resulting from conditions that are common to the neighborhood or the general public, may not be the basis for granting a variance. So sadly, I do not think that this proposal has standing against the stated regulation here. I would hope that there is some way of coming to some sort of term that would help these to a little bit. I've listened to the young statement. I like them. I think that they do face a problem that they did not anticipate. But I think that unless some sort of compromise can be reached, I would recommend the board decline their presentment. Thank you.
Okay, hold on. Any questions for this witness? Okay. Yes, Arrington.
I'm sorry, what was the last part of your last sentence? You would recommend what?
If there's some way to find a compromise between what they're asking and something that's a little bit less invasive and a little bit less dangerous to the precedent, that would be one thing. I sympathize with their situation. But I think that the risks of the proposal as presented have implications down the line that the town might consider disadvantageous. I think it sets a precedent for throwing out variances for various reasons. I think that it weakens attention to the privacy of neighbors and that sort of thing. And I'm sorry to have to say that because I like the folks. I think I understand where they're coming from, but I do think that there are objections
Okay.
go bail it.
Any other questions for the witness? Okay, thank you. You're excused. Anybody else going to come before the board with testimony? You need to be sworn in. She'll be right in. Okay. Approach the mic and just tell us who you are,
Yes.
please.
Ann Walker, I'm Boo Walker's daughter, and I was here when the house was built, but not old enough to pick up a hammer. I wanted to just clarify why that lot is wedge-shaped. I think that makes a bit of a difference. With Hurricane Helene, we lost about 15% of our land, and when we were getting some rock to shore up the undercut cliff that appeared after 60 years of enjoying being right on the creek. And part of that was because the circular driveway around a very, very large rock about the size of one of the ordinary type whales, that was our playhouse as children growing up, and now we have the grandchildren getting ready to enjoy the house. The reason why the lot is wedge-shaped is that when my dad had a carpenter and a stonemason, who's William Harris from Swannanoa, fabulous artist, put the house together. So we had to move the house. There was no other place to set the house. It was an architectural design. It's only 1815 square feet, but it has 4 large bedrooms and a big great room, and it's a beautiful home. And so when the pavers came out to pave the driveway, my dad approached both Ms. Woodhouse, who was the original owner of the house, it's now the Lakes, and Ms. Linton, who was a Japanese missionary, and said, how about if I trade 5 of front for 15 of back, and I'll pave your driveways. And that was actually done. Fast forward to about 1995, when my parents retired. They lived in Davidson. My dad still had the mortgage on his office, so he's working on 3 mortgages, and I'd been paying that mortgage for about 6 or 7 years, and so I bought the house. And when I bought the house, when the Jones, who were just north of us, bought the house, we had to go ahead with a survey to confirm that line. And they were happy to do that, and it worked out fine for them. The house was already there. It's another 1920s type of house. The other side, we thought now's the time to go ahead, since we're doing a deed and we're doing a transfer of deed. So our lawyer got the surveyor, and I went out today, and the stakes are still there, and they're now flagged at exactly the spots where I think they are. But the house is, the lot is wedge-shaped because, again, he wanted to be on the creek. He wanted to be quiet, private. Privacy was living in the forest was the big thing. Building a new house is a little anxiety-provoking for us because we think that, it will probably take clear-cutting the lot to build a house. At 427, here at 429, we're set. But we codified that, and that's why the front is there. And I don't think it doesn't seem like it would be 45 feet, but that's why it is there. So it's a historical thing that started with the gentleman's or lady's agreement, but then was put into the deeds, and that's why it's still there, and that's why I believe your survey is accurate.
You had to please address the board.
That's right.
Thank you.
Okay. So we went and all the spray painted points and all the orange tops of the original stakes are still there. So the reason our home looks a lot bigger is because there was an unopened road bed that was supposed to go up behind Flint Rock Inn, and this is again in the 20s. And it was never actually completed, but there is a big, there's a big road up there past the Velvet Moose and all that. And so that was an unused roadbed. And in the process of buying the property, my dad negotiated with the town of Montreat, and they allowed him to purchase that piece of land.
Okay.
So that's why it looks weird on the plat.
Okay.
So it sticks out, and that's part of why we're that close to the creek.
Okay, well, wait a minute. We may have some questions for you. Anybody have any questions? None? Okay. You're excused.
I just wanted to
Thank you.
clarify, the
Thank you.
dimensions of the lot were set first in that May, and then we made it formal.
Okay, thank you.
Ed,
Yes.
I'd like to have a ruling from Brandon on this.
Okay, sure.
Ann Walker was the beloved pediatrician to my children. So if I can be recused from this decision, if I'm not needed for the quorum purposes, I should step back. I believe I should. I wasn't aware that she was going to speak. I didn't know that this was going to happen. But she's family to my family.
One moment.
Could I have long enough to get a glass of water?
Sure, I'll wait for you.
Thank you.
I'm in charge. Want some water? Yeah. You want to get some water? You want to get some water? You want some water? You missed a seat. Can't hear you. We'll find out when we discuss it. We'll find out.
All right, in the disclosures section read by the chair prior to this meeting, I believe he said something along the lines of the parties to this case are entitled to an impartial board. A board member may not participate in this hearing if, among other things, that board member has a close relationship with an affected person. I believe that you classified this relationship as being closer to a family member or a close friend. I believe that that could be the basis for recusal. It sounds like the board member believes that it would be appropriate for recusal. If the board agrees, I believe that the board may recuse this member. It would need to have a vote and, or a motion, a second, and a majority vote for Mr. Horn to be recused. Mr. Horn, if you were recused, we would ask that you step down from the dais.
Okay. So I have a question. Does any board member have any objection to what they've heard from Mr. Horn? That's one of the questions I asked at the very end. Is that correct? Does any board member have any objections to Matt being part of the discussions and voting on this request?
We have to have a motion to recuse or not to recuse, right?
That's right. I think at this point, I think it would be appropriate for there to be a motion to recuse Mr. Horn. If that motion passes, he would be recused. If not, it would be his obligation to continue to participate.
Okay. Okay. Is there a board member that wants to make that motion or not?
I'll make the motion that Mr. Horn be recused from this particular decision.
Okay. Is there
Did
a
I say
second?
that okay?
Is there a second?
May I second it? I'm requesting recusal. I mean, I want to be recused.
Can I second?
Yeah.
Are you sure you can second? That's why you're here. Okay, so it's been moved and it's been seconded. Any discussion? If my feeling is, I'd rather you not, but if that is your feeling, I'm not going to force you to be part of this decision if they, okay. So that's my discussion. Any other discussion? Okay, hearing no other discussion, all those in favor of the motion say aye. Aye. All those opposed?
No.
It passes. The majority of the board approves that Matt be recused from the.
May I remain in the room, or must I leave the room?
You may remain in the room. Just, we would request you leave the dais. Thank you.
Okay. All right. Watch your head. Okay. All right. Any other testimony? You want? Is that proper? He can come back on.
I think just for the sake of efficiency, I would make sure that you were done, that there are no further witnesses before the applicant has an opportunity to give some rebuttal testimony.
Okay, fine. Are there anyone else want to give testimony? Hearing none? All right, Mr. Young, come on up.
I just wanted to address the precedents that had been set. This is some observations that I had made right around the area of this, of where this property is. There's a carport on Arbor Lane that's 5 feet from the road. One of the homes, 15 feet facing Arbor Lane, has a stream running under the house. Is it an intermittent or what they call an ephemeral stream? I don't know, but it has water running under it today because I've seen it when I took my dogs out. One home is 15 feet from another frequently flowing stream. And that's the same one on Arbor Lane. And one home that has the stream under it. One home has an intermittent stream flowing through the backyard. That would be Lila's home. One book house is about 8 feet from the road. Now, these are grandfathered. Some of them are grandfathered. The one on Arbor Lane with the stream running beside it and the stream under it is not grandfathered. That house is not more than probably 15 years old, maybe 20 years old, because I can remember when it wasn't there. And I've been coming to the house on Kentucky Road for probably the last 25 years. One home about 15 feet from the road has the intermittent stream that we're talking about flowing through the backyard, and that's a very recently built home. And then another garage on Kentucky Road is 12 feet from a stone fence, which is right next to the road. I'm assuming the stone fence would be on the property line. And so that garage is 12 feet back from the road as well. So regarding precedents, there's quite a few things that are in violation of current requirements. So that's all I wanted to say.
Wait. Any questions for what we just heard?
No.
None? Okay. Okay.
Thank you.
You're welcome. Okay. All right, no further testimony. So, Brendan, one question I have is, I know we use the 7 we use the 7 for percentages. Do we reduce it to 6 now, or do we still keep with the 7?
It still stays at 7 for
Still
the
stays
purpose of supermajority calculations. That's
Okay,
right.
thank you. Okay. All right. So, do any board member need a break before we do open deliberations? Nobody? Okay, then we'll go into deliberations right now. Okay. All right, let's start. George, why don't we just, any comments, questions, considerations for the board?
Not at this point.
Not at this point. Okay, this is it. Okay. Mari.
I think that my concerns are that this property hasn't been purchased yet, and even though it was in June that they discovered that the lot was a lot smaller, it's still, they had an opportunity to back out of it. My problem is having a hardship with that. I can't see a hardship with that, because they don't own the property yet. And even if they did, I'm not sure I would, because they had the opportunity not to buy it. That's just my thought.
Mr. Chair?
Yes.
My advice to the board would be to evaluate this without considering whether they have a significant property interest. They do have a contract to purchase the property. So I would encourage the board to look at the hardship issue and without regard to the ownership or the ability to sort of back out of buying the property. I would look at the actual request that is before the board, and whether when you look at that request, you see a hardship. So that's something that I would encourage this board to look at, just to make sure that the decision is based in North Carolina law.
Thank you. We'll skip over me for now. Bill? Nothing?
No.
Dan?
Yes, I think I would speak against this request. And the basis of that is I don't think the hardship case has been made. I don't think it's, I don't think the lot is showing itself to be peculiarly different from other lots in the neighborhood. I'm also concerned about the importance of maintaining a 30-foot setback from an intermittent stream. I think that's a really important. Variances are there for a reason. We have put a lot of energy into establishing variances. We have a very high bar for granting variances, and I don't think that bar has been met.
Okay, thank you. Arrington?
I don't think I could vote for it either. Because it's been my understanding that each individual property stands alone. There is no real precedent set because each property is separate. So its hardships should be considered separately from any other house in town being built. Am I wrong about that?
No, that's what you feel. You're not wrong. Yeah. Okay. I want the board to consider this, and this is the part I'm a little unclear about, is, and I'm sympathetic to it, this 18% which they discovered, was that based on a survey that the town of Montreat provided them with? No. Or the Buncombe County provided them with?
I don't know the answer to that, but staff has not provided that to them.
Okay, well, you're the town of Montreat. Okay, so I'm trying to understand, and I would understand the hardship more, I think, if they were given bad information by the town or by the county, and they base this decision, and all of a sudden they find out that, hey, we're 18% less than we thought, and now we have to require setbacks from the town. So I'm trying to understand, now, if their surveyor gave them the wrong information, I don't think that's the board's responsibility to make up for a mistake that was from a survey that they have hired. So I'm trying to understand where this 18% came up and how they found out about it and from what source they found out about it. And that's one of the, I think it's numbers, one of the hardships is something they didn't do on their own. This hardship occurred beyond their control. So unless I hear differently, then I'm going to assume that came from their own investigation, nothing from the town or from the county. Okay. All right.
Mr. Chair?
Yes.
One more thing that I want the board to consider during deliberations is you really have two variances in front of you. You've got the variances from the zoning ordinance for lot line setbacks and a variance from the general ordinance stormwater section for the 30-foot stream buffer. So if there's any discussion that needs to occur to differentiate opinions based on those two variances, I just want to remind the board that as you're considering these variances, it's really two variances.
So we need to take two votes?
I think that would be best. So
Okay.
two separate motions, two separate votes.
All right. So, Alexis, I have in front of me the findings of fact.
Also, talk to the board a little bit about this sheet. So
Okay, sure. Everybody see the sheet in
what
front
this
of them?
is, Angie, our clerk, the board's clerk should have given all members this. Ms. Cox, you may not have one. I can run you a copy if you would like, if you do not have.
About the stormwater.
Do you have a sheet of paper that looks like this?
In front of you.
This right there.
Mm-hmm.
Yeah.
Yeah, it's front and back. It says findings of fact and motion worksheet.
One side's an approval and one side's a denial.
You
I
can probably
don't-
take Matt's.
All right, so this is just a form that will help the board make the spoken motion. It's not really a part of the staff report or anything like that. It's kind of just a way to help making the motion easier. It does not state the motion one way or the other.
Oh, I see.
It is, on one side it is for approval, on the other side is for denial.
Okay.
There's also some blank spaces for various items. You do not have to use this. If it is not helpful, please feel free to make a motion. You all are experienced board members, so you aren't obligated to use this. I just thought it might be helpful.
Okay.
But I think that two motions
That's what I was gonna ask.
are appropriate here, or I'm sorry, it could be, if you followed this format, it would be a motion on the finding of fact, a motion on approval or denial, and you would go through that twice, once for the stormwater and once for the general ordinance, the stream buffer issue, and once for the lot line setbacks.
I have a question. If we don't approve the variance for the house, isn't the stormwater issue moot?
I think that there are, maybe. However, I think there are two variance applications before the board, so I would rule on them both.
Do you have a question? Any questions?
Well, we can adopt these. It says that I move the board adopt the following findings of fact, and we can adopt this, and that just follows right along. So I see that, right?
Well, it's also-
Or adopt or not adopt, right?
That one's a denial, one's a denial?
Right.
Okay. Okay. So, Brendan, I'm asking for a motion at this point to approve or not approve the variance for the setbacks?
I think that's And again, board members, I don't, this may not be helpful at this time. We may want to go over this in a training or another meeting.
Yeah, okay. Okay, so I need here a motion from a board member to approve or deny, a motion to approve or deny the required setbacks for the front of the property. Is that correct, or the back?
It doesn't need, you don't need to do each side.
Okay.
I think that you can do one motion for the variance request for setbacks.
Okay, fine, easy, okay. Do I hear a motion to approve or deny the request for a variance for the setbacks?
I'll try to make a motion.
Go.
Mr. Chair, I'd like to move that we deny the request for setbacks based on not meeting the hardship requirement in the findings of fact.
Is there a second to that motion?
Second.
Okay. Moved in second? Okay. We deny the approval of this variance for the setbacks.
To be a vote, Mr. Chair.
Yeah. Any discussion on this?
Mm-hmm.
Okay. All right. All those in favor of this motion, please signify by saying aye.
Aye.
Aye. All those opposed?
Aye.
Okay. So let the court record it as 5 votes for the motion and 1 vote against the motion.
That's the motion to deny.
Deny, right. Danny.
Mr. Chair, I'd like to make a second motion.
Okay.
And that I would move that we deny the request for a stormwater variance, again, based on the findings of fact not being adequately met.
Okay. All right. You heard the motion. Is there a second?
Second.
All right. It's been moved that we deny the request for the variance for the stormwater variance. Good?
Second.
A second.
We've seconded.
Okay, all right. Moved in second. Discussion. Hearing no discussion?
No.
Call for the motion. All those in favor of this motion to deny the variance, please signify by saying aye.
Aye.
Aye. All those opposed? Okay, the motion carries 6 votes in favor, no votes against. Okay. All righty. So, let's see what else is on the agenda.
Mr. Chair.
Yes.
The next item on the agenda is writing the written order.
Yes.
Given the, given the complicated nature of this order,
Yes.
it may be a better idea to continue that and review the written order at your next meeting, to give me sufficient time to draft an order for this board to review. I know we typically try to do those right after a vote is taken, but I want to make sure I have sufficient time to draft the order.
Hearing no objections,
Well,
we'll do
I've
that.
got a question. If the next meeting is in November, would it be appropriate to have a special meeting if that's within 2 weeks or 3 weeks or whatever, just to be done with it? Or are you recommending we wait till November?
No, we could have we could schedule a special meeting to do that, or
Smart thing to do.
It seems like what would be the purpose of rushing that meeting because there's no,
Just to get it
not
over.
holding anything else
Yeah.
up.
Just to get it over
Well,
with.
we could do that in November.
Then just
It's not solving any urgency issue in anyone else's.
clearing the decks.
Yeah.
Got it. So,
Why did you say November?
I thought that's when we meet next.
No, we meet monthly as needed.
We meet monthly. Oh.
Brendan, I think Bill didn't understand. We meet monthly as needed, not November.
Mr. Shu, our next meeting would be September.
Right, thank you.
Okay.
Okay, all right, good.
Yeah.
All right, any new business for the board? Okay. Yes.
May we have a motion to continue the written order to the board's next regularly scheduled meeting?
I'll
And
move that.
okay.
Okay, second?
Second.
Moved and second, we continue this until our next meeting, September the 24th, for the written order. All those in favor say aye.
Aye.
Aye. Opposed? Okay, approved. Okay. Next meeting, September 24th, 2026, as needed. Can I have a motion to adjourn, please?
And you'll be gone. That's what you want.
I need a motion to adjourn.
I was not happy.
Arrington, give me a motion to adjourn. A motion to adjourn. A motion to, please. Okay, Arrington?
Question a second.
Okay, second. All those in favor say aye. Aye, opposed? We are adjourned.
Good meeting, Mr. Chair. Right, yeah.
To be honest with you.
Oh,